We're really here to answer questions. We don't have any prepared statement. French family is here, but they will not be answering any questions. Debbie Mahaffy was unable to join us. You heard her victim impact statements, and it's been a very stressful day for the families. We're obviously relieved by the decision. We don't take anything for granted. It was a very difficult process for the families. It was very difficult for the families to hear Paul Bernardo's evidence, if you want to call it that, his explanations for his crimes. We're certainly also relieved, not just that day in full parole was denied, but that the parole board, with obviously reasons to follow, have reaffirmed the dangerous offender designation that was found by Associate Chief Justice Patrick Lesage 25 years ago. And so that's very important to us. It's very important to the family that people understand that not all people who have been convicted of first-degree murder and sentenced to life imprisonment are also declared dangerous offenders. And so the fact that Paul Bernardo is also been designated a dangerous offender, and that has been upheld today, is very important, because we do believe there's a qualitative difference between the considerations that the parole board gives when considering whether or not to relieve someone from the dangerous offender designation, as well as whether to relieve them from the consequences of their life sentence. So in that regard, we're very pleased. There are issues that I think have arisen today, which you may have identified, and it's something that we have before the courts. It's the parole board itself, and I think I think it's important to say that we were very impressed and pleased by the hard work of the parole board panels. I think you can see that they really rolled up their sleeves. They took this very seriously. They obviously put in a lot of time and effort to understand the file, and from our point of view, made the right decision. Having said that, what is disturbing to us is that the entire criminal justice system, and indeed civil justice system, is completely transparent. For all you in the media who were with us 25 years ago and attended the dangerous offender sentencing, for example, or hearing, and the trial itself, everything was transparent. So why all of a sudden we get to the other end of the criminal justice system and everything is not transparent? And so it struck us that when we're hearing from the parole board members about certain reports, certain documents, or even when Paul Bernardo talked about a certain doctor and a certain assessment, we only know what we're hearing at the hearing itself. That would never be permitted in a criminal trial or a civil trial. And there's another case of which the Frenches and the Mahaffys are involved in, dealing with another offender by the name of Craig Monroe, who murdered Police Constable Michael Sweet in 1980. And in that case, we're before the federal court on a very important, what we believe to be freedom of the press, freedom of information case. And as I said, the Frenches and the Mahaffys have joined in on that case for the court to adjudicate that the parole system should be as transparent as the criminal justice system trial is, so that all of us should have the benefit of the reports that everybody's relying upon, and what Paul Bernardo attempts to rely upon to be paroled. And the reason why we're not entitled to it is because of what we're told is Paul Bernardo's privacy rights. And there's nothing private about this. This is a public hearing. Paul Bernardo seeks a public disposition, a public remedy, to be relieved from the consequences of his dangerous offender designation, to be relieved from the consequences of his life sentence, and to be reintegrated back into the community, where the ultimate test for the parole board is public safety. So every aspect of this is public, and I don't accept at all that neither the victims nor the public at large, the media, is not entitled to this information because of the offender's privacy rights And that's the case that's, as I say, is presently before the Federal Court of Canada, and we'll see how the court adjudicates in that case. If Paul Bernardo wants his privacy rights, then he doesn't have to seek a public remedy, and he can stay in jail. But the moment that Paul Bernardo or Craig Monroe or any other offender who's been convicted of first-degree murder and sentenced to life imprisonment, the moment they seek that public remedy, their privacy rights are waived. And finally, I would say that even under the privacy legislation, there is a balancing that goes on when you make an access for information request between the privacy interest of the offender and the public interest. And I can tell you in the case of Paul Bernardo and in Craig Monroe, both corrections and parole have held in favor of the privacy interests of Paul Bernardo and Craig Monroe. So, I hope that by you viewing the hearing itself, I hope that you had questions yourself when you hear references to these doctors and these reports or incidences or whatever, and we just have to take everybody's word for it. And that's just not the way our system works. So while we're relieved by the decision, we're pleased by the decision, I think that we have to examine the whole parole system a little bit more in terms of its transparency.
Mr. Danson, Paul Bernardo talked about a lot of things, horrible crimes, and a lot of words were used, but he never apologized to the families today. What do the families have to say about that? And would they like to address that?
Well, it's a very good question, and it is something that we were discussing ourselves, that even before today, and it is in the victim impact statement. I know Donna referred to it specifically in her victim impact statement, that there's never been an apology by Paul Bernardo. There's been never any indication whatsoever of remorse. And other than, I think some self-pity that we saw today, there was nothing that we saw where Paul Bernardo reached out to the family to say, I'm sorry, and that he's remorseful. What he talked about was he knows that what he did was wrong and it was terrible, but that's something different than reaching out to the families and apologizing to them directly.
Would Mrs. French like to address that at all? Would it be a disappointment or something like that?
No, I mean, they've been through a rough day and quite frankly a couple rough few months, so they're here, but they're not going to answer any questions other than what I've just said. It is a matter of they observed it, they noticed it, it bothered them, but didn't surprise them.
Can you say anything that you could possibly say?
Was there anything that Paul Bernardo could say?
Realistically, is there anything possibly he could say to make this better for the family?
Well, probably not. I mean, you can't erase what he did, but nevertheless, I think for all victims, even though it doesn't, it doesn't make them, it doesn't eliminate the hurt and the pain and the anguish and the despair. It is a matter of observation that he never reached out to apologize, and I don't think that the reason why, in my view, he didn't apologize or show true remorse is because he is a psychopath, and psychopaths are incapable of empathy or remorse. And so I think that what it does is, it's not so much that it would make the family feel better if he said he was sorry, because it would be pretty hollow words. But it's very relevant to the test that the parole board has, which is public safety. And when you're incapable of doing that kind of apology and showing that kind of remorse, you're reaffirming the medical diagnosis that you're a psychopath and incapable of it.
Debbie Mahaffy talks a lot about what this process did to her family. The family was trying to heal 25 years after this horrible thing happened. Can you tell us a little bit about that?
Well, I mean, it's interesting because I've, for better or for worse, I've represented many families throughout my 38 years as a lawyer who've been victims of violent crime, and it seems some families stay together, like the Frenches have, and Doug and Donna and their extended family have been a source of tremendous support to get them through this. And other families, it just rips them apart. And unfortunately, for the Mahaffy family, it's kind of ripped them apart, and it's caused incalculable damage, and it's unfortunate. But having said that, they're still close. I mean, Dan and Debbie are still very good friends, and Ryan, their son, is still very close. but unfortunately they're apart.
She talked about the preparation for this hearing being particularly difficult. Talk a little bit about that.
Well, I would say for both Debbie and for the Frenches, this was a matter of a lot of discussion, to a point where it really starts with, we can't do it. We just can't bring ourselves to even attend, let alone write a victim impact statement. And that resulted in a lot of soul searching and serious thought. But ultimately, and it's my experience, this happens. There was no way that Paul Bernardo was going to be in that room asking for parole without the families representing their daughters. And that's the determining factor, that Kristen's and Leslie's presence was felt today through their victim impact statements, through them being here at the parole hearing, and for Doug and Donna to be here right now.
Are they planning to be here, the families, in 2 years from now?
Well, we'll have to deal with that when it comes, if Bernardo pursues it. I suspect he will. I think a lot of what he does is personal entertainment for him. But it is something that, I think this is going to give us a further impetus to go back to the government for legislative change. I think there has to be a different treatment between people who have been convicted of first-degree murder and given a life sentence, as opposed to those people who have fixed sentences and they're going to get out at some point in time. I think that the 2-year review process is cruel to victims, and I think that the legislation should be changed to at least 5 years apart. And maybe if people want to complain about constitutional rights with respect to people who murder children, I would still say that it should be a minimum of 5 years apart after the initial hearing, unless they have some breakthrough in medical science or a medical report that would allow them to bring an application to be heard shorter than 5 years. But my experience is 2 years goes by very quickly, and it's unfair to the victims. And I think the government needs to look at that and change it.
What were your questions of him today? Were they active?
I thought that he was Exhibit A, to be frank. His explanations about justification and his self-esteem, I don't think that he had an appreciation that he wasn't helping himself. But as I said, and I mean this sincerely, I thought the parole board members were very well prepared and had really done their research and understood the file and asked important questions to bring out some of his responses. So, we really do applaud the parole board for that. But when someone like Paul Bernardo talks about, well, what my trigger is low self-esteem. Let me just take that by itself. In light of his history, there isn't an expert in the world of psychiatry and psychology that wouldn't tell you that his explanations were proof positive that he represented a very serious threat to public safety, and even more so for the board, as they did do, reaffirm the dangerous offender designation, which is a very high threshold of dangerousness. So I don't think he did himself any good. I do believe that, as you know, that today's hearing was recorded. Even though this was a public hearing, neither I, the victims, or you, the media, are entitled to get a copy of that tape and get a transcript of it because of Bernardo's privacy rights. That's also part of our lawsuit in the federal court. I think that there should be a transcription of today's hearing, and I think it should be before the federal court in our hearing, so that the court understands how important it is for the public to view the underlying medical reports. So if there's a medical report, and let me be hypothetical, say there's a doctor, a psychologist who says, I think that Paul Bernardo is at a low risk of reoffending, and he gives his reasons. Well, if that happened in the criminal trial or at the dangerous offender hearing, you would actually have that report, and you would be able to go to other experts to comment on it, so we can evaluate, the reliability of that report. That doesn't exist in the parole system, and I think that, I think they do a great job, but I think the public confidence in the system would be that much more if the system was transparent.
What do you have to say to your colleague, Mr. O'Connor, when he says, parole is not clemency, it's not for forgiveness, it's a provision by law to rehabilitate. We have abolished death penalty in this country in 1976, but we don't bury them behind walls. We call them a correctional facility for a reason.
Well, my response to that is, I suppose he had to do the best he could given what he had. The problem with that statement is that it fails to draw the distinction between the overwhelming majority of inmates in Canada who have fixed sentences. And we really do need to distinguish between those people who have fixed sentences and those people who have life sentences, and then in this case who are also designated dangerous offenders. So I didn't think that was very helpful, and I think he's wrong. Clearly, people who have fixed sentences, meaning they're going to get out at some point in time, you do want to get them out on parole, to reintegrate them into the society to manage the risk. But with lifers, that doesn't apply. So I think it certainly caught my attention. I was not, it wasn't a submission that I agreed with at all. And I might say, I think I do want to say this, and I think Doug has expressed this in the strongest language. And we'll see, he might even change his mind and come to the mic, but we won't let him. But Doug was very, very upset. I think he has a very good point, and the families at large have this concern. Why is it that Paul Bernardo, a lawyer, is able to address the parole board at the end to make submissions with respect to risk management, risk assessment, when the family's lawyer is not able to rebut that or make a submission as well? And I think Doug raises a really a good point, and it's something I think we need to pursue, even if it means legislative changes. I mean, the victims do victim impact statements, but that's quite different than when you saw Mr. Connell do at the end, which is to make a submission why Paul Bernardo should be granted parole. And I think that fairness is that the parole board should hear from the victims' families as well on that point. Is that it?
Can you tell me who's all here? Donna and Doug?
Yes, and Pam, and daughter, and son-in-law. So, and of course Debbie was here with a friend, but as I say, was very, as you could see, was very difficult for all of them. But Debbie just felt that she had to find some peace and quiet at this point in time. So, thank you. Okay.